Hello, everyone. Good evening. Happy Friday. Usually, everybody loves a Good Friday.
Hi, everyone. Thank you for your patience with us with these technical issues that we were having. We're still kind of having some of them, so bear with us. We will get to answer all your questions. Please let us know if on your end you see anything wrong with the audio or the video. Our video may be a little off, but I think you guys can all hear us. Just shoot us a quick message in the comments. Let us know if you can hear us. Please and thank you.
It is also
Okay.
Friday.
It's just everything seems to be working against us today when it comes to this technology. Um, we're trying our best. We really are.
StreamYard also thinks it's Friday.
Yeah.
It knows.
Yes, yes. I think StreamYard just doesn't want to work. It's saying it's Friday. Please let me just go home. But we need to provide our people the information that you guys need. Okay, so I see. Hi, Gloria. Gloria says that she can hear us and see us. And then I
That's
have
good.
Giselle here says that she can hear us, but that the image is slow, video is lagging. Okay. So we are having issues with the video. That's what I thought it was. There really is no way around it. I'm so sorry, guys. We truly try to do the best and give you guys like the best live that we can in terms of content, but it seems to be that we're just going to have this video issue. But I think you can hear us fine. So I'm going to go ahead and we're going to go move forward with the live. Send us your comments. Let us know what questions you have. We're going to be here to answer any adjustment of status questions so that we can help you guys get the information that you need.
Yeah, so make sure you drop your questions so that we can help you with whatever you need. And we're really happy that you guys can hear us because
Yes.
that's obviously the main concern.
As long as you can hear us, I think we can keep moving forward, but the the video will have to deal with that later, I guess.
Oh, yes. We've seen some approvals on the group. We've seen combo cards. We've seen green cards. We've seen people traveling with combo cards. So that's super exciting. I really hope that everyone will be able to join that team, the green card team.
Yes, very much so. Can we talk a little bit about Lorena, how crazy fast the approvals are right now in California?
Yes. Oh my goodness. It's insane, actually. It's really
I've
insane.
I don't think I've ever seen adjustment of status approvals go that fast. Like we're seeing people do this. I mean, literally with under 20,
Mhm.
under 60 days. I don't think
Yeah,
I've ever seen it be
me
that
either.
that fast.
Me
So
either.
to you guys all in California, man, enjoy it. Take advantage of it. File your adjustment of statuses so that they can go as quickly as some of our other group members have been getting. It's crazy. I wish I'm jealous. I wish I was out in California.
Honestly, everything is coming in pretty hot.
Yes, for sure.
Okay, Perla said, hi, I joined the group to be able to help my mom in 2 years whenever she's able to get petitioned by my brother. Oh, it disappeared.
I know. I'm trying to.
It's okay. I'll finish it up where I can see. Petitioned by my brother. Would my oldest brother be able to be the sponsor if needed? He has DACA. My youngest brother is 19 and is a U.S. citizen. Mom's brother should be able to get petitioned by your brother. Does Perla, does your mother have a legal entry? Please let us know so that we can elaborate on the rest of the other questions. But as far as the sponsor, anybody can be a sponsor. It can be a friend, it could be a relative, be a close relative, a distant relative. As long as they meet the requirements, they can be a sponsor.
So there, I do want to add on here with Perla. I
Thank
think
you. I just saw
she
that.
did it come up the comment? I think it did, right?
Sorry, no, continue. I'm so sorry.
Okay.
I
No,
I
you're fine.
realized that. Go ahead.
So I was just gonna say with Perla's comment, and I just want to make sure, Perla, you're saying that I want to make sure I'm understanding what the question is, that you are gonna be sponsoring, or your youngest brother is gonna be sponsoring your parents. Um, and you're wondering if the oldest brother can be like a financial joint sponsor for the 864. Um, if so, that actually wouldn't work out because it looks like you're saying that your older brother has DACA. And so USCIS, they require that any joint sponsors for the Form 864 have to be either lawful permanent residents, US citizens, or a US national. So it doesn't have to be a family member, but it does have to be somebody that is in one of those three statuses. So again, US citizen, a lawful permanent resident, which is a green card holder, or a US national. So unfortunately, the older brother that's a DACA recipient, his income would not be able to be used in terms of being a joint sponsor. So you may have to look for someone else there that can help you out.
Yeah. And Nathaly, thank you for catching that. I missed that part when it dropped from the screen. So thank
No,
you.
no,
But
you're
yes,
fine. I know we're
that is
having the
absolutely.
the video lagging issue, so I figured it must have been something along those lines.
That's okay. I'm glad you caught that.
So there
Um,
is a comment here from Carolina Saldana. I'm gonna try to see if I can put it on the video if it even works. But she's saying, can I use the same USCIS account number on all forms, even if the account number is my own account as beneficiary? So Carolina, I'm assuming maybe you have a USCIS account number from your DACA renewals or an AP application or something else that you've applied for before with USCIS. So that account number, it stays to be, it sticks to you. So that's your USCIS online account number. When you
mhm.
file for anything else, including adjustment of status or another AP, if you are choosing to do so, it is in your best interest to input that USCIS account number on all the forms. It's just so that they can know, that this particular case pertains to this person, and then they can go ahead and put that case on your online account. That way you can track it online. So yes, definitely keep using that online account number on all your forms. Wherever it is that you can input it, make sure you input it in there so that you're not missing out on having your cases on your online account. All right. Do you see any other questions, Lorena, that you want to answer? I know they're going by pretty
Um, I think Bedla added on that she did request her CBP FOIA already last month, but she had a visa B2. I don't know if we can. She said,
quick.
I asked her, sorry, I asked her if her mom had a legal entry, and she said that she had a visa B2.
Okay. So I mean, if her mom had a B2 visa, most likely she did have a legal entry.
Correct.
Yeah, I wouldn't. I don't see someone coming in a different way if they have a B2 visa. What you're gonna want to do, Perla, is look for proof of that legal entry. So that CBP FOIA, it should have something on there about her entry where it talks about like what port of entry she came through or the date of her entry, or the I-94 record would be ideal. And if not, if she has that old passport,
Hmm.
if she came in with a passport, she has that old passport with the CBP stamps on it, that works as well.
Yes. Or
So
even if she
maybe,
has the,
oh, go
sorry.
ahead, sorry.
No, I was going to say that she could also, if she has those flight tickets, I know maybe we don't keep our old documents, but I know our parents always used to keep documents.
Yeah,
So maybe if she happens to have those as well, she can use those.
yep, definitely. Definitely can. So she sounds like she's gonna be good if she has that B2 visa. she probably does have that legal entry. It's just about finding the documentation for it. Let me see. I see a comment after Perla's Giselle. Let me see if I can put this one on here.
Giselle, I just did my biometrics for the I-45 today and wanted to expedite my combo card, but I think I need to wait till they send me the letter saying they will reuse the biometrics for the I-765, right? Or can I just expedite my green card? I sent my package March 9th, 2023. Hi, Giselle. Thank you so much for your question. If you are wanting to request an expedite, you do need to have a reason. They will ask, USCIS will ask what is the reason for the expedite, and it also needs to be a valid reason to request that expedite. And sorry, I'm also okay, letter saying, I'm sorry, I'm reading the second portion of it. It says,
You're
letter
fine.
saying they will reuse the biometrics for the I-765. If you do not need to wait for the biometrics to come in, you can send it in if you have the evidence. You can definitely request to expedite.
If I
I
can
don't know,
just add
Natalie, if you want to add on to
on,
that. Yes.
yeah, if I can just add on, Giselle, it sounds like you're saying that you actually went to your biometrics appointment today for the 45. So when they send you to biometrics for the 45, they actually use those biometrics for all your forms. So they use it for the 765 as well. So you're not going to get a biometric reuse letter. So once they have your biometrics, you're good to go in and expedite if you choose to. So go ahead, go on uscis.com.gov. Go ahead and click on that you want to chat to Emma. Make sure you have handy your receipt numbers. You're going to want your receipt numbers for the I-765 or the I-131, whichever one that you're going to be expediting, or both if you're expediting both. And also I normally recommend for people to have like if you have that notepad on your computer, kind of have a reason for your expediting typed down ready to go, because some of the agents on the like the Ask Emma that are answering your questions, some of them go really quick. So they'll ask you what your reason is, and you'll type in like one word, and then they'll go, okay, submitted, and then they'll leave the chat, which is not in your best interest, right? You kind of want to give more of an explanation to your reason. So I normally tell people, have it ready to go, type up, highlight it, copy it, and then when they ask you why you're expediting, you can just paste that entire thing and send it to them. So that would be my little, add on there.
Yes, it's a great idea.
I'm gonna click here. We have Jorge Garcia from YouTube, watching us from YouTube. And I think his question is about advanced parole and how many months is advanced parole, is it being approved? Hi, Jorge. Thank you for joining us from our YouTube channel. Advanced parole right now is taking between 3 to 4 months to be approved. Seems to me like they're speeding up a little bit. They're getting closer to the 3-month mark instead of the 4-month mark. But that tends to be the average right now that we're seeing under DACA specifically, is about 3 to 4 months that they're taking to approve. Now, there are some DACA recipients who are a little unlucky, and their case got sent to, I believe, the Nebraska Service Center, and that one is backlogged quite a bit. So we have like a handful of people that have been waiting for a lot longer than 4 months. And some of them have actually gone ahead and tried to move their case from the Nebraska Center to the other center that's processing them. But the average right now for most people, I would say, is 3 to 4 months. I don't know, Lorena, if you could agree. I think that that's about average of what we're seeing.
Yes, it is 3 to 6 months. That's what we are seeing.
Perfect. All right. Let's see. Perlas is okay. Thank you. I'm going to see if I can move down to some of the other questions. Let's see. I see one here from Janet. Janet RDZ. Janet pregunta, ¿ustedes ayudan? Oh, where did it go?
I can read it.
I'm
It says,
sorry. Yeah,
ustedes
I lost it.
you're okay. It says, ustedes ayudan para el proceso de ajuste de estatus. Hola, Janet, buenas noches o buenas tardes, depende en qué parte nos estás viendo. En este momento estamos en el proceso de ofrecer ese servicio para poder ayudar a nuestra comunidad migratoria con su proceso de ajuste de estatus. So, vamos a estar anunciando una fecha muy pronto.
If you can see the other comments, go ahead, Lorena, because I'm having my whole system is
Right.
lagging. So go ahead.
That's okay. I can't click them, but I can see them.
Gotcha.
Okay, Fabiola Sandoval. Oh, there's one on here. Sara Baez. Form I-45 is checked yes on the example for question 71. Have you ever entered the U.S. without being inspected and admitted or parole? Is that the date we got to the U.S.? I cannot. I'm a visual person. So give me just a moment. I can pull that up so that I can see, just so that I'm
I
certain of
think,
what we are answering.
yeah, Lorena, I think that's question 77 on the new version of the form. Have you ever entered the US without being inspected, admitted, or parole? I think it's part 8, if I remember correctly. It's all the yes and no questions.
I think so too. I just want to see it. I'm visual.
Yeah, no, I am too. That's one of the few that always stands out because I know with a lot of our DACA recipients, most of them do have to answer yes to that question because they initially entered the US without
Right.
inspection. So that question there, what it's asking you is ever. The keyword there is ever. So it's not asking you was your most recent entry with
Right.
inspection or parole. It's asking, have you ever in all of your entire life came into the US without being inspected, admitted, or paroled? So for those of us who came cruzando, came through the border without inspection, we would answer yes to that question because you did initially enter without inspection. And for that question, I believe you are required to provide a brief explanation at the end of the 485 form and the additional information section, which is the very last page of the form.
Okay, Natalie, I did want to, if you don't mind, I'm looking at the I-45 form right now for part 8, and question 71 is, have you ever lied about, concealed, or misrepresented any information on an application petition to obtain a visa, other documentation required for entry into the United States, admission to the United States, or any other kind of immigration benefit?
Yeah. Yeah, I think I think it's because she says here on the example. So I think it's because she's looking at the old version of the form where the current question 77 used to be question 71.
Right.
Yeah.
Well, yes, because 77 is, have you ever entered the United States without being inspected, admitted, or paroled? So that's correct.
Right. Okay, gotcha. But
So,
71 would only apply, I believe, to individuals that came in with with inspection with a visa or something like that.
Right. And Sada, what you want to make sure is to update that form. That's an old form. So you need to make sure that whenever you're sending in your I-45, you're sending the correct updated form.
Yes, as a public service announcement to everyone, whenever you guys are filling out forms, make sure you're getting that form directly from the USCIS website because they will always have the most up-to-date form on their website.
Yes. And they change them often.
Yes. Oh my goodness, do they change them often? They actually just changed recently the 693. Didn't change too much, but they did update that one recently.
Yes, there are some slight changes there. Okay.
All right. If you see any more, go ahead, and answer them.
I'm gonna go back to that's okay. I'm gonna go back to Fabiola Sandoval. Fabiola Sandoval, saludos. Ella le pregunta, ¿puede alguien que acaba de agarrar su residencia pedir a alguien? Buenas noches, Fabiola. Depende de Usted puede someter, disculpa, una petición para un familiar, pero el único, hay varios requisitos, ¿verdad? Para poder solicitar a pues, puede ser un familiar cercano, especialmente para la residencia, porque usted en este momento es residente permanente y aún no es ciudadana americana. Entonces, el proceso es un poquito más largo. Es necesario que la persona pueda, ¿verdad? Em, ellos pueden hacer el proceso consular o pueden hacer el ajuste de estatus, depende en cómo ellos entraron a los Estados Unidos. Entonces es importante saber cuál va a ser nuestro, like, how do you say approach? Nuestra avenida, cómo es que vamos a hacer el proceso, o sea consular o sea ajuste de estatus. Natalie, know if you want to help me out with my
No, you
Spanish here.
got it. I think no, that makes sense. O sea, la pregunta es si acaso pueden pedir a alguien, que si pueden, como dice Lorena, sí, puede pedir a algunos familiares, ¿verdad? Con restricción, los residentes no pueden pedir a todos los familiares, pero como dice Lorena, tiene que uno planear un poquito, planificar un poquito más allá que tan solo la petición de 130, porque siendo residente, el proceso generalmente es consular para los beneficiarios, que significa que hay que planificar el proceso consular y probablemente un perdón. Para eso necesitaría asistencia legal de un abogado, definitivamente.
Exacto.
Okay, I think I can see the next one here from Carolina Saldana. She asks, do U.S. citizens have an alien number? My husband had an A number from when he was a resident, Form 130. Hi, Carolina. Thank you for your question. So it depends. Not all U.S. citizens have an A number. Most U.S. citizens who were born in the U.S. Received their U.S. citizenship just through birth by being born here, do not have an A number. And that's because they don't ever have an interaction with USCIS where they've had to be issued an A number. But anyone who is a US citizen who originally was not a US citizen, who was a green card holder, or maybe at some point they were undocumented, or they had some other type of non immigrant status or temporary status, all those individuals would have an A number. And so, actually, for your husband, if you look at his naturalization certificate from when he became a US citizen, his A number will be on that certificate. So that's one quick place to look for it. If he has his old permanent residency cards, it would be on there as well under the USCIS number. So I guess the answer to your question is yes and no, depending on whether they were born a US citizen or naturalized.
Yes, that is correct.
Right. Do you happen to see the next one by any chance, Lorena?
Yes, I am looking at it right now, and it's going to be from Daniela Davila. Daniela is watching us from YouTube. Hi, Daniela. Thank you so much for being with us today. Your question is, what is the difference between Form I-130 and I-130A? Also, what is the poverty guideline for a household of two? So the I-130 is the petition from your family member. That'll be either your spouse, brother, sister. I'm sorry, actually, you're asking for the I-130, so that is actually going to be for a spouse, I-130A. So that'll be from your spouse. And the I-130A is a supplemental form for the I-130, and the I-130A is going to include the information. The information on that form will be primarily about yourself, versus the I-130 is going to be primarily the petitioner. This is their request from USCIS to petition for you. And both of these forms will have to be filled out by the petitioner. And then also for the poverty guideline for a household of two, if that family member is in the military, that would be 19,720, and if they are not, that'll be 2,450 that would be the income for the year that they need to make to at least be able to sponsor you. You do need to submit both of those forms. Both of those forms, the I-130A is fundamental to the I-130 if you are being petitioned by your spouse.
And I just wanted to make one quick note there in terms of signing, because I know people get really confused sometimes. So the I-130 is always signed by the petitioner, because like Lorena said, primarily it has the petitioner's information. It's filled out from the perspective of the petitioner. And then the I-130A, which is the supplemental spouse information for spouse beneficiary, that one is filled out from the beneficiary's perspective. So it's usually signed by the beneficiaries, just so you guys know. And for my individuals that are not being petitioned by their spouse, just to reiterate what Lorena said, this is specifically when your petitioner is your spouse. Okay, so my people out there that are being petitioned by their adult U.S. citizen children that are over 21, you would not have to fill out 130A. You don't fill it out. You don't include in your packet. It's not for you. It's only for those being petitioned by their spouses.
Absolutely.
Great.
Thank you, Nathaly, for adding that.
Oh, no worries. I'm still stuck, so go ahead.
It's okay. Our next question is from Bridget C. Romero. Bridget is asking, we are doing consular process and now changing to AOS. We are going to use an approved I-130 and no longer using the lawyer. How can we pause the consular process? I don't want to close consular just in case for any reason AOS is not approved, that we can continue with consular. Thank you, Bridget, for your question. You don't need to pause your consular process. As a matter of fact, whenever you have an I-130, it always gets sent to the National Visa Center. Your I-130 will be pending in their system until either you adjust your status or you move forward with the consular process. Obviously, the one thing you won't do is upload supporting documents, or you could if you've already gotten that far. I'm not sure how far advanced you are into the I-130 or consular process with the NVC, but what you would do is fill out the AOS documents, all of the requirement documents. That'll be the I-45, the I-765, the I-864. If you want to, you can submit the I-131 as well. That's optional. But there's no need to really pause it. There's no way to actually really pause your case unless you want to resend it from the NVC. And that's not something obviously you want to do. So you would just continue with the AOS process. They will be able to see that you already have a approved I-130. And then the NVC will notify, or I'm sorry, USCIS will notify the NVC or verify with NVC what the status is for your I-130 and vice versa, and that will get your case rolling. So that'll obviously, the next step would be obtaining your green card.
Mm-hmm. I just want to add on really quickly, Bridget, and this is what I tell all of my people that are switching from consular to AOS. Please, please, please make sure that you are logging into that CEAC SEAC account for the consular process every 6 months. It's supposed to be once a year, but if you miss it by a day, you don't want to miss it by a day. So I always just tell people do it twice a year. Every 6 months, log into it just to keep it active. As long as you log into it once, it keeps it active for a year. For those of you that may not have the login information, let's say your lawyer never gave that information, you can submit an online inquiry with the NVC, fill out as much of the information as you can on their inquiry form, and then just simply tell them, I don't have the access codes, I don't have the case number in order to log into my CAC account. Could you please provide that to me? They usually will respond within 2 to 3 business days with the information that you need, and then you'll be able to log in just to keep it active. Because if it does go inactive, that's where you're going to have issues with USCIS pulling that information about the I-130 from the NVC.
Correct. And Natalie, if you don't mind, and also there are going to be some of our members who have an I-130 who their I-130 is already closed.
Yeah.
And you can reopen that case by submitting an inquiry as well. So that is an option if you've already submitted one, if it was already approved, and for some reason the attorney or either just discontinued, or anything can happen in life, right? And for some reason you didn't continue with that process, you can reopen that I-130.
All right. So I can see the next question. It's from Luis Esteban on Facebook. Thank you, Luis, for your question. And says, hello, what is the first step to do AOS through marriage? Any recommendations? My current lawyer is charging me too much. Okay, Luis. So my first question to you would actually be, does the beneficiary have a legal entry? So that is going to be the first requirement for adjustment of status. The next requirement, you're mentioning marriage, is the petitioner a U.S. citizen? So those are the first two things you want to look at. If you meet both of those standards, you have your legal entry, your petitioner is a U.S. citizen, then really the first step is just, take a look at the forms. You can go on USCIS, download all of the forms that you need. The ones that are pertinent are going to be the I-130, I-130A, if you haven't done those already. Like if you're not switching from consular, then you need to include them. And then the I-485, the I-864, and then optionally but recommended the 765 and the 131. If you're not on our AOS group page, please join us there. Take a look at our guides, take a look at our files. We have templates, and we have guides for you to follow, just so you can get an idea of what the process is going to look like. And then if you have any specific questions or you get stuck along the way, just post your question in the group. We'll get to it, we'll post it, and we'll answer it so that you can keep moving forward. But that would be my first step, is to do a little bit of research, look at the forms, and look at the guides that we have available for you. All right. I see the next one too, but I want to make sure it's the right one. Dos Mundos, is that the one?
Yes, Dos
Okay.
Mundos is asking, DACA first time applicants, do we have any hope? I don't want to call you Dos Mundos, but that's your username. Thank you so much for your question. At this time, first time DACA recipient applications are not being received, unfortunately. However, the only DACA applications that are currently being received are from those who have previously requested have DACA, and they are renewing it. If you have been a DACA recipient in the past, but you have let your DACA expire for more than 1 year, unfortunately, those are also considered first time application, and those are also no longer being received. We currently have the case with Texas, right, that has unfortunately put a stop on the DACA application. So at this time, there is no way for us to predict what is going to be the future of DACA. But at this time, DACA is staying for those who have previously obtained the DACA status and were able to secure that for the time being.
Hopefully. The only thing we can have is hope for those.
Yes, absolutely. All right, and I believe our next question is from Giselle. Give us just a moment so we can put that on the screen for you.
I think that should have worked.
Yeah,
I know we're still lagging.
I'll read it. That's okay. I'll read it anyway. Giselle was asking, I tried to expedite, but the agent said it's too soon to expedite. I'll be kicked out of my husband's health insurance plan and my grandma. Giselle, I know you asked the question. Give me just one. See if I can go back to the other one. You said, can I expedite my green card? Okay. Okay, I understand. Try to okay, so the question, all right, let me just for everyone so that if for those of us that are just joining out, I will repeat both of the questions. Giselle initially asked, I just did my biometrics for I-45 today and wanted to expedite my combo card, but I think I need to wait till they send me the letter saying they will reuse the biometrics for I-765, right? Or can I just expedite my green card? I sent my package on in March. And the follow-up question was, I tried to expedite, but the agent said it's too soon to expedite. I'll be kicked out of my husband's health insurance plan and my grandma. So I'm not sure where the health insurance ties. I'm assuming this is a sort of medical emergency or health emergency, and that is perhaps the reason why you may be requesting the expedite. Um, I also there, I also do not currently know in what process your application is. So, I mean, obviously it was received. I don't know if it is actively being reviewed by USCIS, but I do know that you can verify that on the USCIS website to see if or where if it's actively being reviewed, if it's gotten past the point where it was received. But what you can do is the USCIS has this really great tool. If you go on the USCIS webpage, and on the USCIS webpage, when you use the tool, it lets you know when you can expect your case to be approved. Nathaly, I don't know if you happen to remember the name exactly, but it gives you like your case processing times.
Mm-hmm.
Um,
I can't remember off the top of my head either.
That's okay. I'm gonna see if I can quickly take a look
Pull
at
it
it.
up.
So you can go to case status online, and you can enter your case number, and it'll tell you um, where it's at, and then you will continue to you can submit a case inquiry as well. That's also an option. And you can also see the USCIS processing times information. And then that's going to be the first step you're going to want to do before submitting an inquiry, because once you see the processing information, it'll tell you when you're able to submit an inquiry to the USCIS.
Yep. So I'm gonna move on to the next question, Lorena, if that's okay.
Yes, that's
I
fine.
see one here by Carol. Carol Nathaly. Hi, Carol. It's nice to see you again. Carol has been in the group page for quite a while now. Felicidades, Carol, para su pareja, que creo que aquí nos está avisando que por fin recibieron la residencia. Carol pregunta, tiene una pregunta, la tarjeta es solo por 2 años. Cuando se acerque la fecha de expiración, ¿qué es lo que tenemos que hacer para renovar? Se paga otra vez. Bueno, Carol, para avisarle, cuando uno recibe la residencia de tan solo 2 años, es la residencia condicional. Esa residencia se la dan cuando ustedes han estado casados menos de 2 años al tiempo de que le aprobaron su residencia. Eso significa que, como le digo, que le dieron una residencia condicional. Lo que eso significa es que adentro de 90 días, and Lorena, please correct me, I think I have that right, I think it's 90 days. Adentro de 90 días de la expiración, ustedes tienen que
That's fine.
someter la aplicación I-751, creo que es el nombre del formulario, que en inglés se le dice removal of conditions, or petition to remove conditions. Básicamente, es a donde usted le tiene que demostrar a UCIS de que aún siguen casados, de que aún tienen una relación y un matrimonio verídico. Y con eso, usted llena ese formulario, sí va a tener que pagar otra vez. Le envía a ellos los comprobantes de que aún están casados, aún tienen sus cosas juntas, viven juntos, etcétera. Y ya cuando le aprueben eso, ya le dan a él la residencia normal, la permanente, que es de 10 años, que se renueva cada 10 años. Lo que debería hacer es siga teniendo sus cosas juntas, sus cuentas bancarias, sus gastos de su hogar, sus seguros, siga manteniéndolos juntos para que así usted pueda demostrar comprobante de que aún están en una relación verídica para cuando le toque a su pareja pedir remover las condiciones de su green card. Pero acuérdese, lo clave, lo más importante es que tiene que someter esa aplicación adentro de 90 días de la expiración de la green card. So, si
Correcto.
digamos su green card expira, um, digamos que su green card expira el 30 de marzo, lo tiene que someter lo más temprano que lo puede someter sería el 1 de enero. Y lo más tarde que debería someterlo es como un día antes de la expiración, pero no espere hasta un día antes de la expiración, ¿ok? Lo más pronto que usted puede someterlo, vaya y hágalo. Si usted va al sitio de web de UCIS y busca 751 Petition to Remove Conditions, ellos hasta tienen como una pequeña calculadora donde usted pone la fecha de expiración de la green card condicional y ellos le dicen, este es el primer día que usted puede someter la aplicación para remover las condiciones. Y ahí es cuando usted debería planificar para enviar ese formulario con los comprobantes. La razón por cual eso es importante es que UCIS tiene una política de que si usted envía ese formulario a tiempo, lo que ellos hacen es que automáticamente le envían un recibo que dice que su residencia está temporalmente extendida mientras ellos trabajan ese caso, cual es muy importante porque ahorita UCI se está demorando bastante para procesar esos casos. Siempre acuérdese de someter eso durante el periodo de tiempo que es clave para que así pueda recibir esa extensión automática. Lorena, I don't know if you have anything to add on to that one.
Solo que el documento, el formulario es el I-751. Y sí, los 90 días, eso está correcto. También lo que sí quería incluir, Carol, no sé si usted tenga hijos, pero si usted tiene o su pareja tiene hijos que fueron, disculpa, solicitado también en ese ajuste de estatus, también tiene que, ¿verdad?, continuar de incluir a los hijos en la aplicación para que ellos también se le pueda, ¿verdad?, quitar esa condición que tienen la residencia. Eso es todo, Natalie.
Okay. I can't see yet the questions, so if you can see the next one, go ahead.
Gotcha. Okay. Karen says, if my AOS gets denied because I have a voluntary return, can I still reapply? A voluntary. I'm sorry, Karen, Natalie, I don't know if you understand that question, but I'm not sure if if you need more. I'm not sure what she means by voluntary return.
Yeah, I'm a little confused by that one too, to be honest.
If, Karen, if you can
So
elaborate, please.
yeah, so voluntary returns are colloquially known as turnarounds or throwbacks. Basically, it's when you're attempting to cross into the United States without inspection and you get stopped by some type of border patrol officer or CBP officer. And what they'll do is that they'll hold you for a little bit. They might take your fingerprints, they might take your photo, but essentially, they don't consider it you having entered the US. It's like you're walking up to the border and you get caught and they say, turn around, go back. So they never count it as an actual entry into the US. Um, that's a little bit of an explanation as to what a voluntary return is. I'm not quite sure. I'm not really understanding the question too well. Where a voluntary return becomes a problem is if you lived in the United States for at least 365 days before your voluntary return. So, for example, let's say you lived in the United States. You came to the United States in January 1st of 2000. And then sometime in 2002, let's say June of 2002, you decided to, go back to Mexico for a family emergency. That means you were in the US without status and documented for about a year and a half. So you left, you went back to Mexico, and then you tried crossing back in. And when you tried crossing back in is when you got, caught, and they turned you back around. They gave you a voluntary return. Well, unfortunately, because there is a record of you having been voluntarily returned, and you were in the US for more than 365 days, you've technically triggered the permanent bar. Even if you then came back into the United States without being caught, the fact that that voluntary return record is on there is what's going to cause the issue. But again, the key aspect of this whole thing is whether you were in the United States prior to that voluntary return. I know there's a good chunk of us in the DACA community and in the immigrant community altogether who may have several voluntary returns when we were attempting to enter the United States. As long as all of those voluntary returns were before you actually managed to come into the US and live in the US for several months, then you're fine. They really don't count towards anything, and anything, it doesn't have any negative impact on your applications or your case. I don't know if that helps with the question that they asked, because for your question specifically, we would have to get more information in order to provide you a more detailed answer. We would have to know, were you in the US prior to that voluntary return, or was that voluntary return, did it happen during you trying to enter the US for the first time? So if you are still on the live and you want to provide those details, feel free to, and then we can maybe take a better look at it.
Thank you. Okay.
I still can't see them. I'm so sorry.
That's okay. Dos Mundo says frozen applications. I'm guessing that is in reference to the DACA question. No, USCIS is not accepting any new applicants at all. The only applications that are being received are those who are currently DACA holders and have maintained that DACA status. So they're not technically frozen. We're waiting on a ruling. DACA's the whole DACA situation is still ongoing. So we're hoping, but we don't know for sure.
Yeah.
La Chiquita Bonita said, "Are you still live?" Yes, we're still here. And then she said, "Oh, I got it." Okay, Silvia Cardona. Hola, tengo TPS, mi hija tiene 22 años. ¿Cuáles son las formas que necesito llenar para hacer mi AOS? Muchas gracias por su ayuda. Hola Silvia, espero que se encuentre bien. En estos momentos se me está comentando que usted tiene TPS, disculpa, y su hija tiene 22 años. Me imagino que ella es ciudadana americana. Si ese es el caso, ella puede solicitarla a usted primero con una solicitud del I-130, que es la petición familiar. Luego, la única forma que usted podría hacer ajuste de estatus es si usted tiene, ¿verdad? Una entrada legal, que es uno de los requisitos primarios para poder hacer el ajuste de estatus. Si por alguna razón usted no tiene ajuste de estatus, tendríamos que hacer el proceso consular, pero me imagino que usted tal vez lo tenga por esa pregunta específica que me está haciendo sobre el ajuste de estatus. Espero que eso haya contestado su pregunta, y si quiere agregar a la pregunta, puede seguir comentando aquí en los comentarios para que podamos regresar. Damaris Reyes dice, sorry, I got stuck in Spanish. Sorry. Hi, Damaris. Hello, Damaris. I apologize for that. Good evening. She's saying, when applying for AP, do they choose for us what airport we need to leave and come in through, or we choose whatever airport? Damari, that is actually a really great question, especially for those who are applying for advanced parole for the first time, and we're super excited for you. So you get to choose what airport you are leaving from and what airport you are coming from. That is totally dependent on where you are going and coming from, whatever is easiest for you, as long as you have the documents that you need. So that's going to be your I-5-112 document. As long as you have that, you are, and your passport, of course, you're good to go. You can leave, depart from any airport, and return into any airport. Okay, our next question is from Esbeide. Hola, la pregunta es, cuando apliqué para DACA en el 2012, yo estaba estudiando para el GED. Tristemente, no he podido pasar el examen. Hasta el día de hoy no me han pedido pruebas en las renovaciones de DACA. Ahora mi preocupación es cuando haga ajuste de estatus, ¿debo tener el GED? ¿Me lo van a pedir? Hola, Speedy, es una buena pregunta, porque creo que eso le ha pasado a varias personas, desafortunadamente, ¿verdad? Y a veces sí hay un obstáculo, ¿verdad? Con el lenguaje o con la vida en general. Cuando uno inicialmente aplicó para DACA, someter alguna evidencia que uno estaba aún estudiando o que tenía el diploma o el GED si ya tenían ese certificado. Era uno de los requisitos para poder obtener el DACA, pero eso solamente se estaba pidiendo con la aplicación inicial. No es necesario de seguir tener ese seguimiento y seguir mandando el GED. Entonces, si usted no lo ha obtenido y todavía está en el proceso, ¿verdad?, de poder obtener su GED, no se lo van a pedir para el proceso de ajuste de estatus. Entonces, no tiene preocupación para eso, pero sí les recomiendo, ¿verdad?, que usted siga intentándole, aunque se le haga un poquito difícil. Y le deseo mucha suerte. Okay, our next question is from Delenia Wright. She wants to know what if for question 77, I think we just lost Nathaly. We'll wait for her to come back, but I'll continue with the questions. Delena Wright is asking, what if for question 77, my lawyer said, I'm guessing your lawyer said check no, but my husband is DACA. My lawyer said no, but your husband is DACA. So, Delena, if your husband is DACA, more than likely he entered the United States without inspection. So if that is the case, then if you want to give me just a brief moment, I want to just take a quick look at that form, because this form was recently, not too recently, but sort of recently updated. And I believe someone also asked this question earlier on in the video. And I'm going to read it out just for everyone who's also watching, just so that we can make sure that everybody, or if anyone else has this question, that we're able to clarify that. So that's going to be part 8, number 77. Number 77. Just a second. I'm sorry, my system is not loading here. I'm trying to pull that up for you. 77. And the question is actually in regards to the entry. It should be like if you were admitted or paroled into the US. If they didn't enter legally, that question is going to be, the answer to that question is going to be yes. Have you ever entered the United States without being inspected, admitted, or paroled? That is going to be page 15 of the form. The answer is yes, unless they had a legal entry. Okay, I hope that was able to answer your question. Okay, our next question is going to be from Dímelo mi gente. Jay Sotomayor dice Dímelo mi gente. Okay. Our next question is from Erika Paloma. Hola, soy nueva aquí. Apenas estoy en proceso para Advanced Parole, pero yo en el 2019 estaba en proceso para la petición. Tengo la forma I-130 aprobada y mi pregunta es esa. ¿Aprobación tiene expiración o tengo que llenar una forma nueva para el proceso de la residencia, que es el green card? Bueno, Erika, Natalie, you're back.
I'm back. I'm
Yes.
trying. I'm sorry. I'm having so many system issues this time around.
That's okay. All right. I'll repeat the question since you just walked in. It's from Erika Paloma. Hola, soy nueva aquí. Apenas estoy en proceso para Advanced Parole, pero yo en el de 2019 estaba en proceso para petición tengo la forma I130 aprobada. Mi pregunta es, ¿esa aprobación tiene expiración o tengo que llenar una forma nueva para el proceso de Green Card, que es la residencia? Hola, Erika. No sé si usted aún tenga esa información, que sería el caso, el número del caso. Si usted tiene esa información por general, uno puede mirar. Si usted lo hizo en el 2019 y no ha entrado a la página del National Visa Center para poder mantener esa petición activa, es posible que ya ha sido cancelada. Es posible que también esté abierta, a veces depende. Yo he visto en algunas ocasiones que aunque la persona no haya entrado a la página en National Visa Center, todavía está abierta, pero si está cerrada, se puede volver a abrir sometiendo un inquiry con el NVC y es necesario poder tener que esa aplicación, el I-130, esté activa para el proceso del ajuste de estatus. Si usted no tiene una petición I-130 activa, usted no tiene, ¿verdad?, su base para poder someter el ajuste de estatus. Entonces, sí es importante que intente de conseguir esa información. El número de caso. Natalie, I don't know if you remember what the other one is, the case number and NBC case number.
It's the case number y el access code, I believe, is the other one.
Yes. Sí, Erika, es necesario tener esos dos, ¿ok? Nuestra próxima pregunta va a ser de Diana Avila. Mandé mi AOS y la forma 485 está en revisión y todas las demás están como recogidas.
I think she meant to put recibidas.
Oh, okay, got it. That's great. That's good news. Estamos esperando que le aprueben la aplicación, entonces ojalá sea muy pronto. Okay. Nuestra próxima. Go ahead. I don't know if you can.
No, go ahead. I'm not. I was going to ask you if you could tell me the name and I could try to click on it.
Oh, Jessica Enriquez.
See if that works.
Hi, Jessica. Jessica is saying, I'm very confused with the I-864 and I-864W. I have my 40 credits. Do I need to send both forms or just the I-864W? Jessica, it is necessary to send the I-864. So whenever you apply for AOS, your petitioner has to submit the I-864. If you need a co-sponsor, I'm sorry, you're saying you're using the 40 credits. So you're saying that you have your 40 credits. Do I need to send both forms? Natalie, can you elaborate on the credits?
Sure. So, so if first things first that I always tell people is double check that you actually have the 40 credits. And when I say actually, it's because unfortunately, the Social Security Administration counts the credits a little too fast. Like they count them in advance. Basically, the Social Security Administration, they will credit you for credits that you haven't earned yet because they're assuming that you're going to keep working for the rest of this year. So when you're checking for your 40 credits, do not go by that little green bar that says 40 credits. You actually have to download your Social Security earnings statement. Check on the second page and you're going to see a table, like a little chart. On that chart, there's going to be several years with Social Security wages next to those years. What you need to see on that table in order to fully earn the 40 credits is to see 10 years listed. So and I'm gonna say DACA recipients because that's the majority of the people that we have on our page. For DACA recipients, because DACA came out in 2012, the most that you could have is from 2012 to 2022, because 2022 is the year that just ended. So what you want to see is you want to be able to count 10 years. So if we're starting with 2022, working our way backwards, if you can see years 2013 through 2022, that's 10 years on its own. And then you want to make sure that each year qualifies by looking at the Social Security wages that it shows up next to it. As long as the most recent count is 6,040. So if all of your years say more than 6,040 in Social Security wages, you're fine. That means you have your 10 years, all 10 years qualify, you have your 40 credits. If any of those years are under 640, then we have to kind of dive into it a little deeper and check to see if that specific year qualified for the 4 credits in full. And we can help you with that. You can always post your Social Security earnings table on the page, and we'll look at it with you and we'll let you know. So let's say that you have checked your earnings table and you are sure you have the 40 credits. Then what you would do is you would fill out that form 864W, and only the 864W. Your petitioner doesn't have to fill out an 864 if you have the 40 credits and the proof for it, because that 864W is actually an exemption to the like a waiver to the affidavit of support, which is the 864. So I guess long story short, if you're completely sure you have the credits and you have the proof to back it up, then you can just do the 864W on its own. You're going to send that earning statement as your main proof of your 40 credits. And then the other thing that we advise people to do is send in a copy of all past and current EAD cards, so work permit cards or employment authorization documents, because those 40 credits only count if they were earned while you were authorized to work. So while you were authorized to legally work in the United States. So Jessica, I hope that answers your question. But if you truly have the 40 credits, then you're good with just the 864W form.
And if I can, just really quickly, if you do not have, for some reason, some of those EAD cards and you've lost them, you can also
Yes.
submit the I-797 approval of your work permit authorization.
Oh, yes, yes, definitely. And then if you don't have those, guys, USCIS FOIA is your best friend. You may
Yes.
be able to get a copy of that receipt from the USCIS FOIA. So either way, there's always a way to prove that you had that authorization, even if you lost your card. All right.
Our next question is going to be from Carolina.
Okay.
Carolina, hi. Her question is, my brother is planning to get married this year. He is a U.S. citizen and will be turning 21 until next year, 2024. Can he still petition for my parents as a married person? Is it best to not get married so he can be a single U.S. citizen petitioning for your parents, for parents? Hi, Carolina. It is not necessary for if your brother is able to get married. He's a U.S. citizen. He has a right, a U.S. citizen right to petition for your parents. Obviously, he just when you do submit that petition, he will need to be able to financially either be that sponsor for them or may need a joint sponsor if that is necessary, but he is able to petition for your parents.
Yep.
Our next question is going to be from Karen. Sorry.
Go ahead.
Okay. Karen's asking, will FOIA entry record be enough proof for AOS? I'm sorry, just a second.
No, you're fine.
Will FOIA entry record be enough proof for AOS if we don't have an I-94? My lawyer sent out Form I-1012 on my behalf, but CBP confirmed that there was never an I-94. For me, thus the I-102 is unnecessary. FOIA entry record. What Karen, it would really depend on what that entry record has. Is it like a passport stamp? Is it a I-94? But it seems like you're also saying that the CBP confirmed that there wasn't an I-94. So I mean, did you submit? Are you saying that maybe you submitted a passport? You would have had to have, what was that proof that you submitted previously?
Yeah, I know. I agree with that one. It's there. I'm wondering what results came from their FOIA at all.
Yes. So we would kind of need to know what was submitted.
Yeah. Feel free to send feel free to post the pertinent portion of the FOIA results in the group, as long as you block off any personal identifying information. Feel free to post it in the group, and we'll be sure to take a look at it and see what we can decipher.
Okay, our next question is going to be from Diana Avila.
Sorry, I'm trying.
That's okay. We'll be on for like another I'm going to say like 15 minutes. So we'll continue to answer your questions for the next 15 minutes. So do not be alarmed. Hi Diana. Diana saying, mandé mi AOS el 16 de abril, fin de semana pasado. Miro que la forma 485 está en revisión desde abril 18, pero la forma I130 y todas las demás están recibidos. ¿Será que me han enviado un RFE? Diana, si le hubieran enviado un RFE, usted podría verificar esa información en USCIS.gov. Si en este momento usted no tiene un RFE o que le enviaron un RFE o ha recibido algún documento de RFE, pues obviamente en ese momento no lo tiene. Lo bueno es que, ¿verdad? Ya recibieron los otros formularios y el I-130 ya está recibido. Puede verificar en el website o si no ha recibido esa carta, entonces por el momento no tiene nada de qué preocuparse. Okay, Miss pregunta va a ser, oh, sorry, did you want to add to that, Natalie?
I just wanted to add really quick. Solo le quería añadir ahí, Diana, generalmente cuando cuando UCIS le ha enviado un RFE, cambia el estatus de su caso y cambiaría a decir que un RFE se ha enviado. So, si está viendo que el estatus dice en revisión para el 485 y recibido para los otros formularios, generalmente significa que no hay un RFE. Pero lo otro que quería mencionar es que no es incomún o no es abnormal ver de que un formulario está en revisión y los otros aún solo muestran recibido. No es algo afuera de lo común. No todos los formularios están en revisión al mismo tiempo. Acuérdese que es una una humana que está procesando su aplicación, entonces es completamente normal que estén trabajando de un formulario parte por parte o paso por paso. Solo hay que esperar, ser un poquito paciente y esperar que ellos terminen de revisar todo.
Correcto. Y ese oficial también es posible que esté revisando otros casos, entonces, ¿verdad? Ojalá que solamente hubiera un oficial para cada caso, pero desafortunadamente ellos también tienen otros casos que revisar, entonces revisan a cómo le llegan y dependiendo también en los otros casos que tienen que revisar. Y si usted recibe un RFE, no se preocupe, de verdad recibir un RFE es muy común. más común de lo que usted se imagina. Solamente quiere decir que el oficial quiere más información o necesita algún otro documento adicional que no fue sometido para la aplicación. Así que no se preocupe mucho si le den un RFE, se contesta, ¿verdad? Se manda la información y luego se sigue procesando el caso. Nuestra próxima pregunta va a ser de Cynthia. Cynthia is saying, I just received my AP from planning to travel at the end of May. I have my I-130 approved and active, was doing consular, and now I have the other documents ready to go. My question is, what time should I do my medical? So Cynthia, this is a really great question because some of us will send our medical exam with our application, and some of us will wait to send it after. It really is, in my opinion, it is a preference on how you want to do it. And the reason why is because if you happen to get scheduled for an interview, when the USCIS officer receives your I-485, they will either give you a deficiency notice and you will be able to present it for the interview. But we are also seeing at this time that a lot of the AOS cases are getting approved without an interview. So if you send it in, it's probably more likely that you won't get scheduled for the interview. So you can do either or. You might get an RFE for it or a deficiency notice. Personally, I would send it with. But if for some reason, financial reason, or whatever reason that may be, that you're not able to send the medical with your application, but you want to make sure your application is at least processing, you can go ahead and send it in.
Just to add on to
Nathaly,
that,
just gonna ask if you wanted to add something to
it. So just to add on to that, I will say that recently USCIS actually changed their policy guidance, and they are now actually advising to send in your medical packet with your adjustment of status packet, to include the sealed medical exam with it. And that's because they themselves are admitting that they are trying to waive as many interviews as possible and try to get people processed as quickly as possible. So, it does, like Lorena say, it goes back to preference, but I will say, kind of take that into account, the fact that USCIS is now actively asking and advising applicants to submit it with their AOS packet. So I would also agree with Lorena. I think it's in my opinion, probably going to be best to send it in with your packet. In terms of what time you should get the actual medical done, there was a 60-day requirement on the medicals, which means that they had to be your adjustment of status had to be submitted within 60 days of the doctor signing the medical exam. But that has recently been done away with at USCIS. So there's no longer that 60-day requirement. So if you have your medical from before, you don't need to get a new one redone. If you fail to turn in your AOS within those 60 days, that one is the one you had from before is still valid. What is important to note is that medical exams do still have a 2-year expiration date. Which means if for some strange reason your adjustment of status takes longer than 2 years, you may be, and you probably will be, requested to get a new medical exam. But caveat to that is we're seeing adjustment of status start ramping up in terms of processing. We're seeing faster adjudications, crazy ones like California, which are 2 months, but then also ones that are closer to 6 or 9 months. So it seems like USCIS is doing something. They're changing something internally to try to get new applications processed and out the door as quickly as they can.
Correct. Thank you. Okay. Luis Esteban is saying, yes, I did AP already. Not sure if there's a follow-up question or if you're just excited to announce you did advanced parole, but we're excited.
I think he had a question before.
Let me see if I can.
I think he was asking about adjustment of status before. I think we asked him if he had.
Oh, I got it. Yes, I can read it if you'd like.
Sure.
He said, "Hello, what is the hello, what is the first step to do AOS through marriage? Any recommendations? My current lawyer is charging me too much."
Ah,
Okay,
that makes sense then, because
got
I think we mentioned
it.
the first thing is making sure your petitioner is a US citizen and that you have that legal entry. So you got that legal entry, Luis. Good job. Now you just need to start on those forms.
Right, and those forms are going to be the I-130, I-130A, if it's your spouse petitioning for you, um, the I-485, I-765, I-864, and submit that medical form as well.
Mhm.
And all your evidence. So we do have some guides that you can follow on our Facebook group. So you'll be able to see all the forms that you need and where you can access those forms from as well. Okay, our next question is going to be from Daniela. Daniela is watching us from YouTube. Daniela says, one more question. I had medical. Do you think that's going to affect me when I do AOS? Am I going to be considered a public charge and can deny my green card? Daniela, I do not recall if you stated what the medical, give me just a moment. Let me go back to your prior question. No, I'm sorry, it doesn't elaborate on that. If you can please elaborate on as what you're referring to medical, I'm assuming it's like some medical condition. If you can please elaborate on what that medical condition is.
Since she's referencing public charge, and I'm just assuming here, Daniela, in case you're still watching us, if you're referring to that you had received some type of medical assistance in the past, like emergency medical assistance, or some type of like I know sometimes when sometimes they'll cover like the labor and delivery through WIC, through some other assistance program. If that's what you're referring to, then no, that will not qualify you in and of itself as a public charge. Um, USCIS recently made a very, very detailed announcement back in December about what they will be looking for when it comes to public charge. And there really are two things that they're focusing on. And if you look at the new 485, it focuses in on those two things. So the first one that they're looking at is cash assistance, and not just any cash assistance, like regular cash income, like income replacement cash assistance. So, for example, if anybody received TANF, if anybody received any form of like regular cash assistance, that's something that would just qualify you as a public charge and would cause an issue. But the good thing is most DACA recipients or undocumented individuals don't qualify for TANF anyway, so there wouldn't be a way for you to have gotten it. The other part that they're focusing on does have to do a little bit with medical, but it's very, very specific. They're looking for anybody who was institutionalized on a long term and that institutionalization was paid for by the government. So that's, for people who were maybe in a rehabilitation facility, some type of like a long-term care facility, and that was being paid for at the cost of the government. So it wasn't paid for privately, wasn't paid for through like an employer's policy or through your family's out of pocket. It was specifically paid for by the government. There's not a lot of people who fall into the category either. There may be a few, but not a lot. So unless you have one of those two, they're really not looking at it for public charge. They actually made a list of a lot of different aids that they're not even taken into account for public charge, like food stamps is not being taken into account in and of itself. WIC is not being taken into account. If your kids had gotten some type of medical assistance or you had gotten some type of emergency medical, CalFresh, CalMed, none of that is being taken into account. If you would like some more details, I would ask you to join our Facebook page, AOS Dreamers Together Official. We have pinned or featured posts at the very top of our page. And if you scroll through those, there's one that's specifically about the new public charge rules that went into effect towards the later half of December in 2022. So take a look at that. It's a very, very detailed explanation. In the comments section, there's a long list straight from the USCIS website of certain welfare or cash assistance programs that do not, I'm sorry, not cash assistance, certain welfare programs or social assistance programs that do not disqualify you for AOS, as they're not being taken into account for public charge. So I hope that answers that question, if that's what you were asking about. Loren, are you able to see the next one?
Yes, that was from Daniela. Our next one is going to be from Jasmine. When are you guys starting the one-on-one for the whole AOS process? And what will be the charge? Hello, Jasmine. Thank you for watching us from YouTube. We are currently in the process of rolling out an announcement. We don't have an exact day right now, but it is going to be probably within the next week or 2 weeks or so. So just be on the lookout for that announcement. We will be opening that up pretty soon.
It's imminent, guys. I think it's gonna be coming sooner than you think. It's very, very imminent. We're just tying up some loose ends so that we can get it out to you in a way that makes sense.
Absolutely. Okay. Our next question is going to be from Juana Centeno. Juana Centeno is asking, when making copies of tax documents, do I need to make copies of every single document? It depends, Juana, on if you're sending a transcript or if you're sending what sort of documents are you referring to? If they're all tax documents, if they are, then you need to submit right, that entire tax application that was originally submitted, or you can submit your tax transcripts, which you can access on irs.gov. You can request them from the IRS on that page. Sorry.
Yes. And USCIS, I think, does have that preference of the tax transcripts, because it's a little easier for them to read, and they don't have to go through, 20 plus pages of tax schedules. So it really may be in your best interest to download that tax transcript if you can. It's going to make your the number of pages that you send in a lot less, while they still get all the same information that they would have gotten from you sending all those pages of the tax schedule.
Oh, sorry. Next question is going to be from, sorry, from Faja. I'm sorry if I'm saying it wrong. What's the website to check your I-130? I'm doing consular, but want to switch to AOS after hopefully getting my advance parole approved. I am actually currently in the process of posting that on Facebook. I will be posting the link. You will need your case number and NVC inquiry number to be able to access that. If you previously had an attorney, you might want to reach out to them so that you can they can provide that information to you. Or maybe you might have it if you want to look through your old emails. The NVC always sends the case number and inquiry number to both the petitioner and the attorney if you had one. If not, then it'll be just to the petitioner, which should be yourself. But I will post that link for you in like 30 seconds. I'm working on that. Nathaly, are you still not able to see?
I think I may be able to read this one. This is from La Chiquita Bonita, and it says, I like that name. And it says, I have my son that is turning 21 this year, and I was told from a lawyer I could get my green card with an application I had since I was little. I forgot the name of that form, but my parents got their green card with that petition we had years ago. So I'm planning to use that in my son as soon as he turns 21. But I was told that if I do AP, I could also get my green card like that. So my question is, which one is a faster process, using a legal entry or using that petition that I had? So La chiquita bonita, thank you for joining us and for your question. This is actually a topic that I love talking about. What you're referring to, I think, is 245I. 245I. So what 245I um, was a special law that was passed back in 1998, where it said that if a petition was filed for you, you were you kind of had this sort of protection, like it forgave unlawful entry, it forgave unauthorized work, it also forgave it forgave unlawful presence. And so a lot of people were able to do adjustment of status with 245I. Now it was extended again in 2000. And so the two key dates are January 14th, 1998 and April 30th, 2001. So, and this goes for everyone out there because I think there's a lot more people that are grandfathered under 245I and just are not aware of it. Check with your, in Chiquita's case, check with your parents. If your parents have a green card, even if they don't, check with them and see if anyone ever submitted a petition for them before April 30th of 2001. If they did, and at that time you were unmarried and under 21, then you're also grandfathered through that petition. So this is what I think is happening with Chiquita here. She was probably unmarried and under 21 when her parents were petitioned, which means she is grandfathered as a derivative. So Chiquita, you definitely can use, if you have 245I grandfathering, you can use that to submit adjustment of status, even if you don't have a legal entry. You can also go and get AP and then get your legal entry if you have DACA, or some other status that allows you to do AP like TPS. Is one faster than the other? Um, I don't think either one of them is really going to make the adjudication a whole lot faster. I will say that with 245I, there is an extra $1,000 fee that you pay USCIS, and there's a little extra, sometimes a lot extra evidence that you have to submit. So for example, remember those two key dates I was mentioning, January 14th, 1998, and April 30th, 2001. If your parents were petitioned before or by January 14th, 1998, then 245I for you would be pretty simple because you just have to prove that you were their derivative, essentially that you're actually their daughter and that you were unmarried and under 21 at the time of that application. So as long as you have access to their original I-130 receipt for their application and their approval, and you have access to your birth certificate showing that you are their derivative, you're their daughter, then that's really all the proof that you need for that 245I situation. Now, if your parents' petition was after January 14th, 1998, but before April 30th, 2001, then you do have to present one extra piece of evidence, which is always the hardest. And that's you have to prove that the principal applicant, which would have been one of your parents, whoever was being petitioned for, was physically present in the United States on December 21st of 2000. It's a very, very specific date. This is where some people get into a little bit of trouble because we're now in 2023. So it's pretty difficult to find proof that someone was in the United States from over 20 years ago. And I know that because my current adjustment of status is actually tied to 245I as well. And so I had to prove that my father was physically present in the US on that date. And I didn't have anything that had that specific date on it. But what you can do is create what we call a evidence sandwich, which just means that you're sandwiching that specific date with evidence before that date and after that date, as close as you can get to it. That is something that you can do. So really, it's up to you, Chiquita, how you want to go forward. If you have 245I, you can definitely use it. If you have DACA or TPS and you can do AP, you can definitely do that as well. Completely up to you. Just kind of have to balance out the pros and the cons of each. I would say look to see if you have the evidence to prove 245I first. If you have it, then it's on the table. If you don't have that evidence, then you know, in all reality, the AP may be your better or easier method forward. I hope that helps.
All right. I think that would be after this one, this will be our last question. That was a mouthful.
I'm sorry.
No, it's okay. It's great information. But I agree. I agree with you on that. All right, so our next question is from Idalma Duran. Idalma is saying, if I received my combo card and have an expiration of 2 years, does that mean I will get provisional residence? I think you are referring to the conditions on your green card. If you have been married for under 3 years, you will typically be issued the conditions on your residence. So it is very likely that that may be the reason. In which case you will just have to renew it, your green card as well as the combo card, whenever you are coming to that expiration date. That would be, if I receive my combo card, yes, so that would be 2 years. So, Nathaly, I don't know if you want to add on to that, but it is very likely that is the reason why you were given the 2 years on
The combo.
your
So I
the combo
actually
card.
do want to add on a little bit here. So I believe, from my experience, all combo cards are issued for 2 years. And if anybody in the comments has gotten their combo card, or any of our fellow volunteers for the nonprofit, I know Laura has her combo card from before. I think Vanessa would have it from before, but I do believe all combo cards are issued for 2 years. So if you got one for 2 years, that's totally normal. Your combo card, usually they do not issue it for more than 2 years. But the only, and I'm literally the only thing that determines whether you get a conditional green card or a regular green card is how long you were married at the time of approval. Okay. At the moment that that adjudicating officer approves the I-485, if you have been married for at least 2 years, you will get the 10-year green card. If you were shy of those 2 years, even if you were shy by one day or a couple of days or a week, you're going to get the conditional green card. So 2 years married on approval, full 10-year green card. Less than 2 days on approval, you're going to get that conditional green card. That is the only defining factor as to whether you get the conditional or you get the full 10-year green card. It's literally the only thing that determines that, when it comes to family-based or spouse petitions. And I do think that is going to be our last question for today. We do have to go, guys, but thank you so much for tuning in. Thank you for all of your questions. Lorena, I think we'll have to do this again,
Yes,
sometimes
there's a lot
soon
of
in the,
questions.
in the next coming weeks, because there was a lot of questions. So keep an eye out. We'll be able to do this again soon. We'll post it with a few days advance notice so that you guys are aware and can put it on your calendars to tune in, and so we can answer any questions you may have. Thank you for joining us today. Lorena, I don't know if you want to sign off or say anything before we go.
I want to say thank you so much. I'm sorry that we didn't get to all of the questions, but hopefully we can. When next time, definitely we'll be able to answer some more of those questions, and we'll be back soon. Remember, you can still ask some of these questions on our Facebook page, the AOS
Yes.
Facebook group. So,
Yes.
thank
And
you
if
so much.
we didn't get to your question right now, we'll be back in the comments answering them through comments. We won't answer them on the video because we do have to get off, but I will be going back in the comments and answering any that we missed in the comments. Okay, so don't fear. You'll get your answer at one point or another tonight. Just give us a few minutes to get back in there. Okay.
Yes, thank you so much. Have a great night. Enjoy your weekend, everyone.
Yes. Enjoy your weekend. Have a great night. Thank you. Thank you, Lorena.
You're welcome. Thank you so much.
Bye.
Okay, bye.